Good day to you all. I'm very happy to be here as part of this great conference. And I know it's 2:30 and that it's a lunchtime, but I think this panel will have a great I think we will have a good quality 45 minutes to discuss an important issue, and that's AI and copyright law, primarily, which is part of the segment that we all know is an IP law. So today we have three great experts, friends and colleagues. On my left side is my colleague Andrea Radonjanin. Andrea is an IP attorney with 15 years of professional experience, who has been working since in company that's or a legal company that's called Schonher. Probably some of you have heard about them. Andrea has obtained a master's degree in IP law and PhD at the University of Nottingham in the UK. She's an expert for IP law, and her expertise is to advise and help clients, companies primarily, to deal with IP issues in their business. Andrea?
Thank you.
Welcome. Next to Andrea is my favorite guy, Branko Kovac. Branko says for himself he's a data enthusiast and an AI consultant at Logica. Branko is a senior expert. Just recently I found out he likes beer, as many IT experts.
IP experts?
Yeah. So, and he's experienced in AI sector. Branko is working as a consultant in the company I just mentioned, and has an experience in delivering effective AI. I would like to know what the effective AI is.
The one that works, actually.
Okay, you'll have your 5 minutes. And machine learning solutions. Branko has joined his skills in developing innovative AI and identifying new opportunities to leverage data for business growth. Branko.
Nice to be here.
Thank you. And last but not least.
First.
Okay. Sorry, I'm keep asking the questions whether you can hear me well. And last but not least, Dusko Martic, a colleague of mine who is a lawyer specialized in cybercrime and privacy law. He holds a PhD in law, science and technology, and he is a head of content protection at United Group, a leading multiplay telecoms and media provider in Southeast Europe. Dusko heads all anti-privacy activities, including investigation to criminal proceedings and IP litigation and enforcement. For us, attorneys and lawyers, that means play at court. He is a member of the legal expert group at EUROPE, or European Union IP Office Observatory, and he is listed as the industry expert in Europol Platform for Experts, in IP Crime Group, and Europol Data Protection Experts Network. Dusko.
Thank you.
So. And I think it would be okay to present the most boring part of this group, and that's myself. Thank you. Some refreshment. It's not beer, but it's I think
good enough.
I think
We'll see.
Branko, would this work? Huh? Okay. Okay. And so myself, you probably heard, but my name is Gajs Ljubomir, and by profession I'm an IP attorney, specialized in patents and trademarks. I'm also a qualified patent agent for the World Intellectual Property Office. I worked as a startup mentor for Science Park in Graz, in Austria, and I also had been involved in regulatory affairs, working for the Committee of AI in Council of Europe, an internal group of implementation of AI in Republic of Serbia. So, having all said, I think we can jump into this very interesting topic that we all, I think, all of us want to know, and that is how this interplay between AI and IP that has been happening for almost 2 years, is gonna evolve or is currently standing, considering that the AI has been an arch enemy of the IP. At least this is what we've known about it, and this is how most of us have the impression about it. So, if you agree, we can start.
Sure.
Andrea, tell me, IP law issues. What is basically the main problem that the companies face when it comes to training AI models and the IP?
Sure, thank you. Well, AI development is certainly the most exciting field of our world today. And it has shown enormous potential to influence various industries and various segments of our life. And at the beginning of that development is AI training, right? So AI providers and AI developers obviously need access to huge amount of data. They need really extensive data sets, millions of pieces of information and materials to train their models. And these data sets often contain works of copyright in the form of books, different kinds of texts, music, videos, graphs, photographs, paintings, whatnot. And what does that mean? That these are works of copyright? Well, that means that, you know, the authors of these works or the right holders who hold rights to these works enjoy certain exclusive rights that are granted to them by law. And these rights relate to the way how their work is disseminated, used, in which form it's published, and so on. So what does that mean for IT developers? Can they use these materials freely? Do they need to ask a permission from the authors? Do they need to pay back some compensation to the authors? Do they need to respect certain limitations? Do they need to acknowledge the source of where they are taking these materials from and who is the author of the works that they are using to train their models on? These are all the questions that we have been discussing the past 2 years, and as in many other situations, unfortunately, the answer is not super straightforward and simple. Why is this? Firstly, because we don't really have a uniform set of rules. We don't have harmonized IP laws around the globe. Different countries, different regions have different laws. On top of that, courts in different countries provide different rulings, different interpretation. And then to add to this complexity, our IP laws were actually designed a while back ago, so they might not be super suitable for this new reality that we are living. And then to just give you...
Which is the main characteristics of law. It's not proactive, it's retroactive. Basically,
it's slow.
It's slow.
It's slow. And especially when we have these kind of super quick jumps and revolutionary steps forward, even though, okay, we all know it's not really that revolutionary. I mean, it didn't happen today, but still law was super slow to predict this and to keep pace. And then just to give a brief overview of where we stand today as it is. Okay, so we said the way copyright works is if I'm an author of something, I created something or I invented something, the law gives me certain exclusive rights. So I'm going to decide if I want to publish my work or I want to keep it in my drawer forever and never let it outside. I'm entitled to controlling how many copies I'm going to, distribute my work, in which way I'm going to publish it. I want to do it in a digital form or some other form. But then the law recognizes that this monopoly that is granted to me, to an author, maybe has to be limited in certain ways because there are some other interests that are also very important. For example,
like public licenses.
Exactly, or non-commercial use. If I'm a university teacher and I want to teach my class, I'm not allowed to copy a book of my colleague in 500 copies and sell it to my students, but I am allowed to make copies of, exactly, to make copies of certain parts of that book and distribute it to my students for the purpose of studying. So we have these so-called exceptions to copyright rules. And in the United States, for example, it's a famous concept, probably most of you heard about about it. It's the fair use doctrine, which is an exception which allows.
We'll speak about that later.
Yeah.
You'll have
But this is the
opportunity to
current.
talk.
Yeah, this is the current status. So in the U.S., you are probably allowed to train your AI model on copyright works without asking permission from the authors or.
We'll discuss that definitely.
Yeah.
But just to summarize, the question is, how can we adapt the copyright law, which is fairly old, towards a new?
I was going to conclude with that. We can discuss that now. That's probably a way of looking forward. Look,
Those are all issues, right?
Exactly. I
To
think
adapt to a new change.
the key thing here would be to strike a balance because, you know, as we know, we have so many conflicting interests here. So on one hand side, we have the interests of the right holders, the authors. They obviously have an interest and a right to enjoy the fruit of their work. I mean, they invested certain time, creativity, skills, whatever, into creating something. So they want to have the right to control what they created, but they also want to be compensated for their work. On the other hand side, we have the AI developers. Obviously, they need access to data to develop.
And Branko will now try to defend against us attorneys who want our rights to be fulfilled. We want our rights to be enforced, right, Branko?
It's true.
So what would, in your opinion, what are the obstacles related to the use of data for training of AI models? Do you see any as someone who comes from the industry? And if you see them, can you just name a few which are most painful in this process of training of AI models?
Any or
many?
many?
No, related. No. Try with some.
No, but really, I mean, it's not a question if there are any obstacles. It's more about like how many or how many more.
Can we name them at least?
We will see in the future, right? I mean, I'm not an advocate of, let's say, completely, you know, free access to all the data, right? I'm kind of, let's say, fond of some kind of regulation, but definitely not strict, right? But on the other hand, what we see or feel as of right now, it seems to me that it's, I don't know, becoming like overwhelming even, right? So it's being like completely pushed at us, like, hey, here it is, a little bit more, right? One more thing to think about, right?
One more checkbox to
one more
to
checkbox,
do.
yeah. And I'm not even sure, you know, what else is actually coming, right? Should there be some? Yes, absolutely. I mean, we all know of people who absolutely believe that there should be none, right? Think about OpenAI, for example, right? They pretty much scraped like the whole internet, right? And then they say something like, hey, it's not enough. We even need your private data, right? I mean, I can understand that kind of approach. Do I like it? Doesn't even matter, but pretty much I don't, right? So that's one thing. But on the other hand, you can see that the internet itself is kind of changing, right?
Self-regulating.
Self-regulating.
In some way.
Should I say, I don't know, it becomes more closed in a sense, right? So I don't know. You have let's say social media like Twitter, X, how it's called now, right? I don't know, a couple of years ago you had API access to it. Nowadays you don't have it anymore, right? It's a problem in a sense of how easy you can get some data, right?
So,
Reddit, they said something like, hey, we are willing to, you know, give like exclusive rights to all of our data for, I don't know how much money it was, like $50-60 million, right? You pay for it and then you can access it. I believe that they even have some kind of block when it comes to automated scraping right now. So that's another manifestation, right? You even have like I don't know, lawsuits, right? New York Times versus OpenAI.
Yeah, we'll discuss that later.
I don't know what happened with it. You probably know better than I do,
Dusko
right?
will tell us.
Yeah, but the point is, it's changing, right? 5 years ago, these were not the topics, right? We didn't even think about it, right? So in that sense, we are now facing completely different situation in which access to data, I'm
It's
talking
changing.
in general, right, is definitely changing, and it's different than it was. It's not so easy nowadays.
So would you say that nowadays, considering that the data is that the main substance that creates an AI model, that this access is now being more complex in terms of legal perspective, and that we are now, you as developer are facing this conundrum of requirements to access data? Is this what you would say as your message?
I believe that that's what we see.
That's what we, okay.
That's what we see. I mean, maybe it's not that complex as we see it. I mean, developers definitely do not have any kind of background like in law practice, right? But it seems to me, I mean, maybe I will be like here a little bit radical, right? When I say you have technology that is changing quite a lot and it's changing fast, right? And you need to adapt it, right? And there are issues, challenges along the way right now. And now you see one more, I would say, major challenge, and that is like, hey, how can we actually access the data, and are we allowed to use it, and how exactly?
So Andrea, I think that he wants to say that the attorneys have all the blame now. Okay, we'll
No,
jump
but those rules
afterwards.
were always here. You just became aware of them
it's
now.
always our fault that we are not so fast and progressive. But anyhow, we will discuss it further.
We also hate lawyers.
Yeah. So Dusko,
I don't know why.
you as one of the heads in the segment of a great company that deals in telecommunication media. So you are the one who is, so I understood, and correct me if I'm wrong, are representing that segment that says authors as creators of original piece of work need to have this sort of compensation for their work if it's an original work of art. Given that we've witnessed that the New York Times is now struggling and having this legal battle with the OpenAI regarding their most famous GPT model. So, are you familiar with the outcome of this situation? And are you familiar with any other court proceedings that have the same topic, and that is whether we can have AI model developed under the fair use doctrine?
Right.
Meaning that we don't have to pay the authors a dime, and we don't have to ask him, but for the good of us all, to have these modern AI applications and to be very super IT and fast. It's nothing against you, Branko. Don't worry.
No offense taken.
So, Dusko.
Yeah, you're right. My work is quite heavily in enforcement of intellectual property rights. There is a need specifically for rights holders to enforce their rights, because otherwise it would be left to any entity, person, to do and use as they will with any kind of content, also to abuse it. Now, having in mind case like New York Times, I guess, an OpenAI, which is quite prominent case. It's been heavily in media, and it's also a good example of also output infringement, because in the case itself they kind of exemplified how you can, with certain prompts, get the exact copy, or largely the copy of the exact same text from the New York Times. And that's a case that's going to have a significance. It's still being, it's pending, so we don't have a ruling there. It's still being deliberated. But over time, we have quite a number of cases that have been
Sorry, I just have to interrupt you. Just for the spectators who didn't maybe have the time to read it through, just give us a few lines about the background of this case proceeding. What is the issue? What does the New York Times has against an OpenAI, which is a fabulous company? They have a fabulous product. What do they have against them? What is their problem?
I mean, we could summarize it as being threatened commercially. You know, why would you need New York Times if you can put a prompt with a specific subject and then get exactly the same output as that New York Times? They will lose market significance, they will lose income. But it's not just about New York Times. There's a number of other cases. And what we've seen over the last year, we have a number of cases that were, well, authors against OpenAI, number of authors. Sarah Silverman, famous comedian, she with a group of another authors, brought the case against OpenAI and Meta. Then there is Get Images versus Stability AI, which is quite important for this topic. Recently in May, there was a case of music industry relevance where the big music producers and distributors filed a lawsuit against Suno AI and Udio AI. And I would say quite recently, very important case, which was, by the way, first ruling that we have in Europe, is a case that was a month ago. German court issued a decision in case of Knežke versus Lion. Maybe it's good to give you a bit of a background there, but there's a German photographer, he's a producer and rights holder, and though he had on his website kind of a natural language opt-out saying that you cannot use my copyright for training purposes or robots or whatever, the Lion, which is kind of a open base or open network for research purposes, used its copyright for its training. Now it went to the court, and there was a kind of a typical argument there where both sides claimed completely different sides of the story. The court actually found very interesting, gave an interesting ruling. First of all, because it kind of looking from the perspective of both sides, it declared that this kind of processing is not temporary, that therefore doesn't fall under that exemption. It does not fall under the exemption of what we use also for fair use, that it wasn't the text and data mining exemption, because there was, even though it's maybe not what we usually thought of machine readable, it is in a natural language, and in current standard natural language processing could be considered as machine readable. And finally, it's exonerated Lion because it was on a research-based person, because it was non-commercial, it was non-profit, and it was open access database, so there was no commercial background. That's why it gave it the ruling in favor of Lion. However, in first two sentences are quite important for the development of further jurisprudence in this specific sector.
Okay, thank you. So when I started dealing with the AI in regulatory segment, which actually enacted 2 years ago, my understanding was if I am a student, if I am an algorithm with my brains, my capacities, whatever they are, and I go to school and I take some books and I take some literature, I read it, I have to become a good I want to become a good student, to become a successful model. I know that I have to pay for those books. If I go to a library, I have to take this card, and the lady who's there for centuries says, if you lose this book, you're gonna pay, I'm gonna call your parents, we're gonna have you expelled, and all other threats that they make in regards to the importance of the book and literature that we use, that we read, that we use to study. So, from that point, Andrea, what do you think? Actually, what is your experience? You, as someone who is, who has had a various and a rich experience with the companies who are doing an AI and implementing the AI technology, do they conduct the compliance check to see whether they line up with the copyright law? And are they actually concerned with these lawsuits that they're just raining all over in Europe and America especially? And are you familiar with any cases that are currently happening in the Balkan area, since you're the expert for this area in this domain?
Okay, but I want to go back to this library example later,
okay,
because I
course.
think it's super interesting, and we always have the discussion, you know, what's the difference? Yeah, but let's talk about practical aspects, because I think a lot of people would like to hear that. So last year in this very same conference, I had a very similar panel with a bunch of fellow legal experts, and we were talking about, training issues, output issues, and so on. But we did it on a purely theoretical and academic level, because a year ago we were not sure. I mean, we knew what the rules were, but we didn't know what the courts are going to interpret, how the market is going to react to this, if it's going to take a conservative approach or not, if the investors are going to pay attention to these kind of things. We didn't know if the law was going to change in any direction or anything. And over the past year, I had a chance actually to take part in a couple of really high level transactions where the targets were local startups who have developed AI tools. And I can tell you, from the perspective of the buyer or potential investor, the market pays very much attention to what you're doing. So this is the public information. I don't have to hide it. We actually worked on the transaction where Autodesk, who was the buyer, we worked as the buyer's counsel, bought Wonder Dynamics, which was a startup from Novi Sad who developed an amazing AI tool for the film industry. And we spent dozens, if not hundreds of hours doing a due diligence of their data sets. And on top of that, we had, I think, a couple, 3 or 4 5-hour calls with a bunch of advisors and the guys from Wonder Dynamics, literally pulling apart their data sets and analyzing from IP and data protection perspective. Okay, guys, what did you use? Did you obtain a license? If you did you conduct an independent copyright due diligence, even though you had a license? Did you use synthetic data? If you were creating your own data sets because they were recording some stuff, how did you do that? Did you clear all the rights and so on? So it was a really important part of that process. And with the new EU AI Act, it's becoming even more important, because the EU AI Act, which was adopted this summer and it's coming into force in certain phases, it doesn't say much about copyright, but it actually contains a couple of very important provisions, and the key one is that the AI providers will need to comply with EU copyright rules. And what it means is that as a developer, you actually need to take care of what you're doing from the very beginning. Because if you forget about it or you don't take care of it and you train your model, I don't know, Branko, correct me if I'm wrong, but I don't think you can untrain your model, right?
You can just train a new one.
Exactly. So you can forget about everything you've done and start from scratch. So if you don't pay attention to this, you might end up having a model which is unmarketable in EU. And with this regard, it's very important to mention that the AI Act actually has extraterritorial reach, meaning that even if you trained your model in the US, based on the, for example, fair use doctrine, you didn't obtain any permission, but you want to market your model or offer it to customers in EU, you need to comply with EU rules. So if you don't pay attention from the onset, from the beginning, you might end up with a model which you can't market, or you decrease the value of your model, or in the end, no investor is going to be interested in giving you the money for your final product.
Yeah, thank you. This just reminded me, or gave me I recalled one case. I was doing something I didn't maybe say. My expertise is computer implemented inventions. So in layman terms, it's software patents. So I was trying to find out something about cases in this area, just to have some ideas how to solve an issue that I had with one case. So I ran up to a patent that was submitted almost 20 years back by a big player in the room, and that's Microsoft. So they patented in the US their software Windows. So considering that, and that so to say, the impression is that the AI should overcome and be on top of everything. Now my question was then, okay, but why did you patent your most valuable product? Why did you protect it? Why did you enforce all the rights against anyone who's copying it? And we had the cases of plurality of infringements of Microsoft and all its products here. So, and we solved that in Serbia as a general issue. But having said that, Branko, do you consult, and your developers, do you consult with experts like Andrea, having in mind all these repercussions that may advance your development and just and your product afterwards end up in a bin if you didn't go through all these steps? Are you having this kind of feeling that you need to go through this? Are you doing it? Or you're just like, they won't find out.
Yeah.
Look, I think that Andrea explained it very well, right? At some point it becomes a question, huge question even, right? You reach the point where you know, are in a process of acquisition and suddenly everything is,
But
you know,
now,
under a
nowadays
question
you know.
mark. Nowadays you
speak
know.
about it.
Nowadays you know. Yes, nowadays you know.
You know
I mean,
what the
for the
requirements
past
are.
year or two, right?
Okay.
Yeah. The question is at the very beginning, because we cannot untrain something, we cannot exclude, you know, later when we have a model. But at the very beginning, do we have resources to really think about it? Right? That's the question. Do we have resources to reach out to Andrea and say, hey, you know, can you actually work with us on these matters? Right? Sometimes yes, sometimes no.
Okay.
Right? And so in that sense, it's a problem. Again, right? I'm probably stating the obvious. No, well, it's not that everybody can pay for it, literally. Right.
Okay, but that's the consultancy base. But considering all the available information today, and the government's investing in that sort of enlightenment of the need to comply with the rules, are you facing the same challenge and obstacle, or you're just trying to now to say navigate through this maze of complex legal requirements?
Look, I think that sooner or later we'll all have to comply. Right, that's reality. The only question is, like, you know, how much time and money it will take for us to do so, and how many setbacks we'll see, you know, during that process. Right. So if we are already halfway, you know, through, I don't know, process of building something, you know, is it going to be something that will ruin us completely, or we'll just, you know, I don't know, introduce some fixes and, you know, continue working? In that sense, I'm just hoping that at the very end, regulation will change soon enough, right? And go with something that will just give us maybe a little bit more space, right, to navigate. Because so at the moment, it seems to me that there is a lot of pressure. I mean, I'm talking from a perspective from somebody who is, you know, working in Serbia with local companies on one hand, but also the U.S. companies, and we are also seeing differences.
And that's my second question. Where is it easier to train a model, in the U.S. or in Europe?
You know the answer.
No. I want you to tell me the answer. Don't tell me.
No, it's the U.S. Yeah, it's
Why?
Like, that fair usage policy is just something that, I mean, it allows you a lot of freedom, right? I mean, you can pretty much still do everything you want, right? How it's called, transformative usage, or right? I'm not completely sure, you know, of the naming, but you know, it gives you freedom, much more freedom that, you know, what we have in the EU, or what we will have in the EU, right? So for us, for example, who are mostly in this services area, it's much better if we have only the US clients, right? But fortunately or unfortunately, we also have to take care of the, you know, local.
Don't forget about us in Europe.
Local situation in the EU, right? So no matter, you know, what situation currently is at somebody's company, right? We will all have to follow, you know, additional legislative, right? And that's it. Let's just hope that this first iteration of the AI Act will stay maybe for, I don't know, a year or two, and then let's make some changes.
Yeah, and to comfort you, me being part of the Council of Europe, we've drafted a convention on the AI, rule of law, democracy, and protection of human rights. So, and one of the parties to this convention is the US, which is now heavily legislating or doing this legislation procedure to harmonize the rules and law so that we have unified practice, so we don't have this kind of feeling that, okay, let's run to the US, train a model, and then try to push to these dumb Europeans to swallow this ball. But I think that we have made the progress, and Andrea and Dusko will definitely have a word to say in terms of getting the knowledge and consciousness that we need to work together, and that the legislation should not be an enemy to development, but should also be a friend to a society, so we don't end up having something that, technology that is unwanted and against the humans.
Harmonization is part of the solution.
Yes,
that's
definitely.
for sure.
I agree. So Dusko, in your opinion, authors, collective compensation, is it possible?
It's possible, potential, one of the solutions. Let's call it like that.
So what would that mean in your terms? Just to
I mean,
explanatory
currently
notes.
it looks like that direct licensing can be more easily ready-made solution right now, especially when you have a rights holder which has a huge portfolio. And we have right now OpenAI licensing directly with big players, and well, probably not general approach, but very specific. And we had similar practices like with Google and Google Books cases and the previous historic similar new technology developments that led to licensing in the end. Collective management organizations are going to be probably one of the solutions. Different schemes possible versus we could use mandatory or voluntary schemes. Just for additional fact, last week German music collecting organization just filed a lawsuit. So representing 95,000 musical artists from Germany filed a lawsuit against OpenAI, probably in direct connection to that case that I mentioned a minute ago. So the whole point was that even collecting management organization that was probably open and still is open for licensing and has rules stated on their website, opted for actual lawsuit. So lawsuits are part of this whole, well, we are currently in very gray area, and lawsuits are building rules and building some sort of case law that will be essential for building future licensing solutions. So we'll see in what cases where it's going to be considered transformative use, where exemptions are going to apply, in what sense and what levels, and giving all these, well, case law and future regulation, we will have probably better outlook on ways how the licensing could be handled. Collective organizations, existing ones, could be the part of the solutions. We'll maybe have new ones specifically dealing with AI. We don't right now have a bunch of them, but this is a need that probably market is going to solve.
Yeah, and in regards to this question, we are now actually aware of the fact that this poses a problem for most of the authors. Some of them are willing to share their knowledge and their works as a philanthropic action, but some of them aren't. And you mentioned one thing, you said opt-out.
Yeah.
So before this EU Act happened, we have had a directive that has passed next to us very, very invisibly, so we didn't notice it, but speaks about something that's important regarding the Trajan models. Could you please give us, what is the point of this what is the name of this directive? If you don't know it by heart, I can read it, but what is has it actually anticipated the problems that we will have now, 3 years after it was enacted? What we'll have as a problem with the training of AI models? Has it foreseen the future of AI companies that deal in AI models?
I would say you're talking about exemptions under Copyright Directive or DSM Directive, which, if you look at specifically Articles 3 and Article 4, you don't see AI mentioned there. It wasn't intention. The intention was allowing non-competitive scientific research or research and not building blocks for competitive, future competitive business models for the rights holders.
So just give us the line. What does it say about, and what is the term? It's not training, it's data mining, right?
Data mining,
Text
yes.
and-
Yeah,
yeah,
that is
text and data
and data mining, TDM essentially. So this opt-out is envisaged in the directive, and by the way, it was this case in Germany. It was specifically about that as well. It is a tool for rights holders, but it's opt-out tool. It puts you already in situation that you have to react and you have to do proactively to protect your copyright, which should have been in your disposal in the first place, to forbid or to have ways to protect its distribution, reproduction, or any kind of use.
So basically, if I'm an NGO or a research and development organization, and I want to take in some AI model, I want to train it, and I need some data, what does the directive say? Can I take from my colleagues from other companies and say, thank you, I need it, or I have to ask and pay? What does the directive say?
It depends on the purpose that you're
so
going.
So my purpose is scientific. I just want to research
for scientific purposes, you could use the data mining
freely. Don't have to ask. Don't have to pay. Woohoo! That's
scientific
perfect.
research. Scientific research. But you have to pay attention actually how this is framed, and if it's purely for scientific research, that could be covered by this.
But also he needs to check if the authors have opted out of this.
Yeah.
So that's another hurdle.
Yeah, please. I want to hear about that. This is another legal but.
Yeah, there is always a but.
Yeah.
It doesn't exclude the rights of the rights holder to opt out. It doesn't want.
What does the opt out mean?
Means that
say
you
no.
can expressly say that you don't want use of your rights for the.
So there is like an implied license for you to use it, but if the author doesn't want his work to be used in that way, he can withdraw this implied license and say, actually, no, I don't want my work to be used for training purposes or for text and data mining, whatever.
And it does, considering that we are dealing with the IT segment, that everything is digitalized. So there is no actually inscription there on a door or table that says, okay, no copyright infringement. Does this opt-out means that if there is an obstacle, a technical obstacle in my data sets, in my database, is this my way of saying you cannot touch it without my permission? Does an opt-out mean that
you need to implement measures?
Yes.
I don't know, Dusko, I know better, but I think that's not even necessary.
No, well, I haven't fully understood the point.
If I hold rich and very, very good data sets that everyone wants to have now in this room, and I've implemented some measures, electronic measures, which say, okay, no, you cannot touch this. Can you actually use this data, breach it, even though you have a great purpose? You want to treat cancer, you want to treat poverty with your AI model. Are you entitled to take my data and say, okay, but this is under this directive, this is something that's very noble of me, and you can't do anything against it, and you can't sue me or
I would say no, unless there is a specific legal ground for this kind of use. By the way, you would risk, private enforcement later, and not necessarily, it's not a thing that it's automatic. There would have to be a civil law case against you later on that maybe judge could consider a different kind of interpretation. But I would say if it's machine readable way and one of the plain industry standards, or even some other, in development standards, which gives you specifically that it's not to be used, you shouldn't be using it.
Thank
freely.
you. And Andrea, now that we've heard all of this, so you're good at envisaging some future paths for us, and you've been successful in this for almost 15 years. What is your future? How do you see actually the future of AI? Do you see us piled up with lawsuits and having all these cases against so honest and good developers that do an AI as a service, as a product? Or should we just expect that the government and the society drops a ball and says, okay, we need to loosen up a bit, we need to change the legislation so these great guys could work and earn money, and so we all have a great society?
Yeah. Well, look, I think we understood today, you know, nobody's really happy. I mean, we have a bunch of authors in the US who are suing big players. And then we have the small developers who are, you know, prevented from working. They need to invest a lot of money, a lot of effort to do this legally. So this is definitely not a good solution as it is. What I think needs to happen first is a bit more harmonized approach, because we have completely different, I mean, in the UK, I don't know if you're aware of that, in the UK, they are thinking about completely overriding copyright for AI training. On the other side, for example, France was considering completely different approach. No, you need to pay the authors, you need to acknowledge them, you need to ask them for permission for every piece of work. So completely different positions.
They can withdraw their permission?
Exactly. No, the permission is not given in advance. You need to go and ask them. So
but
first
I mean, the authors can withdraw their permission anytime.
Yeah, anytime. So a bit more harmonized approach, and then an approach, again, circling back to this idea of balance, where we actually take all these interests into consideration, and not just the interests of individual groups like developers, right holders, and so on, but also the interests of the society as a whole, because the society, you know, needs research, needs development, needs creativity, needs free competition, and so on. So, you know, creating this balance doesn't mean completely overriding the interests of one group, but I think if we, you know, take another step back and not just think about it as lawyers, but see the bigger pictures, I think we need to think about what is fair. And I don't think it's fair to just, you know, take somebody's work without paying anything back, but then we also need to think how to balance this system to allow it to evolve further.
Because, yeah, the authors, bottom line, sometimes use these GPT models to
actually
check the
fight
books,
infringement very often, or something like that. Exactly. So
yeah, give us some ideas. Maybe we're not so creative at this point. So we do use technology nowadays. And the last question, Branko, now, you have been a guy who's now sitting between three lawyers, and it wasn't hard for it wasn't easy for you, but
you did well.
Yeah, you did well. So, what would you say? What would satisfy you? What would be the ideal model that you would suggest and say, okay, guys, this is something I, as an IT expert, as someone who's consulting IT experts in this area, what would be the ideal model? How we could should we keep on fighting, or should we keep on trying to meet our ends and to just strike a balance?
I know that they're urging me to keep it short.
Okay.
Yes, please.
So just give us
collaboration, right? Fair payments for the authors and right holders. Transparency, definitely, that we know what we are paying for, and harmonized rules. Yeah, definitely. If we can make it like that, it will work perfectly, I would say. Yeah. So I kept it short, right?
Including transparency on what exactly has been trained on, which is a very important fact for any kind of development of collective licensing or any kind of future solution. So that part cannot be, well, kept on side and black box paradox, so we don't know what happened or whatever. So we need as well.
And we as authors should not be greedy. Yep. And we should understand that this is something that we all use, like Google Translate, like any tool that we nowadays use, so that we should work in some coexistence rather than fighting each other. So I think that this panel has come to its end. I hope that you enjoyed, that we didn't overburden you with some legal issues, legal statements. The future is bright, that's what I can say, and for myself, and I see it like that. And if you have any questions, I think we have 30 seconds. 30 seconds, just one question, please.
No, ask us afterwards.
Yeah, or you can ask us afterwards. But hope you enjoyed, and have a great lunch if you didn't have them. But if you didn't have it, if you had them, I hope you have a great time at this conference. And please be free to ask us after this panel whatever you wish regarding the AI and copyright law. Thank you.
Thanks.